Our Father in heaven, holy be your name. Your kingdom come, your will be done on earth as it is in heaven. Hail Mary, full of grace, the Lord is with you. Blessed are you among women, blessed is the fruit of thy womb, Jesus. Glory be to the Father, to the Son, to the Holy Spirit. Dear Lord God, bless and guide and help us as we prepare for the bar examinations. Grant us wisdom, understanding, clarity of thought, facility of language, and expression. Make us succeed in our efforts. This we pray and ask of you in the name of Jesus Christ, your Son, our Lord. Amen. In the Father, of the Son, of the Holy Spirit. Amen. Good afternoon. So let us continue now with our discussions of the significant areas in the Bill of Rights. Now, we were discussing last night Section 1, the right to due process of law, the right to the equal protection of the laws. Two important rights in Section 1. So I repeat, when we talk of due process could either be procedural due process or substantive due process. In essence, procedural due process refers to the method or manner by which the law is enforced, while substantive due process requires that the law itself, not merely the procedures by which the law would be enforced, is fair, reasonable, and just. So there you are. And because of that, we tackled the Mark Jimenez cases. Particularly the first case, Secretary of Justice versus Honorable Ralph Lantion. The second case, although we tackled that yesterday, but actually it's more the second case is not really due process. It does not involve due process. Kaya lang tinakal natin yan because tinakal na rin natin ang Mark Jimenez cases so that there will be continuity in the discussions. So, during the earlier, first of all, in that ruling, obviously what was involved in the Mark Jimenez case, the first case, Secretary of Justice versus Honorable Ralph Lantion, what was involved there was procedural due process. During the initial evaluation stage in an extradition proceeding, is he entitled to those documents he was requesting so that he can prepare for his defense? So anong sabi ng Supreme Court? Not yet at that stage. Because here the court, by applying the balancing of interest approach, ruled in favor of the more compelling state interest. What is that more compelling state interest? To prevent the escape of potential extradites which can be precipitated by premature information of the basis of the request for his extradition. Eventually, he will be given those documents when? Once the petition for extradition is filed in the RTC. So that is but a soft restraint on his right to due process at that stage. There is no denial of due process for as long as fundamental fairness is assured a party. Okay? Be guided by that ruling. Thank you. Now, another development in this area, and in recent cases, medyo napapadala sa pag-invoke nito, yung void for vagueness doctrine and the doctrine of overbreadth. The twin doctrines. void for vagueness doctrine. The other one is the doctrine of overbreadth. Now let us tackle the first. Void for vagueness doctrine. What should be declared void? The law, the acts of government, the measure. It must be declared void, it being vague. Why vague? So take it from there, void for vagueness doctrine. The law, the acts must be declared void for being vague. Why vague? Because it lacks comprehensible standards, so that men of ordinary intelligence will probably have to guess as to its meaning and differ in its application. If that be the case, then the law or the act should be declared void on that ground for being vague. Kaya void for vagueness doctrine. So I repeat, the law or the act must be declared void for being vague. Why vague? Because it lacks comprehensible standards, so that men of ordinary intelligence will probably have to guess as to its meaning and differ in its application. According to the Supreme Court, such an act, such a law, is repugnant to the Constitution in two respects. First, it violates due process for failure to accord persons fair notice of the conduct to avoid. Second, it leaves law enforcers unbridled discretion in carrying out its provisions. And in effect, it becomes an arbitrary flexing of the government muscle. That is the void for vagueness doctrine. If the law be such, it being vague, it lacks comprehensible standards, so it becomes repugnant to the Constitution in two respects. First, it violates due process for failure to accord persons fair notice of the conduct to avoid. Second, it leaves law enforcers unbridled discretion in carrying out its provisions. And in effect, it becomes an arbitrary flexing of the government muscle. Okay, take it from there. So what should be declared void for being vague? What should be declared void for being vague? The law, the act of government. It could be an ordinance. It could be an administrative regulation. It could be an act of the president, a pronouncement by the president. It could be a statute enacted by Congress. That law, that statute, that ordinance, that pronouncement should be declared void for being vague. Why is it vague? Because it lacks comprehensible standards, so that men of ordinary intelligence will probably have to guess as to its meaning and differ in its application. If that be the case, that act, that law, is repugnant to the Constitution in two respects. First, it violates due process for failure to accord persons fair notice of the conduct to avoid. Second, it leaves law enforcers unbridled discretion in carrying out its provisions. In effect, it becomes an arbitrary flexing of the government muscle. Because indeed, can you just imagine being held liable for violating a provision of law which you never understood in the first place, since it is vague? It strikes deep into the very essence of due process, holding you liable for violating a provision or an act which you did not in the first place fully understand. It strikes deep into the very essence of due process. You're being deprived of life, liberty, or property without due process of law. Okay? Now, a good example of that was in that American case, Coates versus City of Cincinnati. Try to analyze. What was involved there was an ordinance enacted by the City of Cincinnati, making it illegal for 3 or more persons to assemble on any sidewalk and there conduct themselves in a manner annoying to persons passing by. So what is prohibited? Was it illegal under that ordinance? Making it illegal for 3 or more persons to assemble on any sidewalk and there conduct themselves in a manner annoying to persons passing by. You can just imagine. That ordinance was declared by the American Supreme Court as void for being vague. Sabi ng American Supreme Court, clearly, the ordinance imposed no standard at all. Because one may never know in advance what annoys some people, but does not annoy others. You get the point? Try to understand, try to analyze. Making it illegal for 3 or more persons to assemble on any sidewalk and there conduct themselves in a manner annoying to persons passing by. How will you know in advance whether your conduct in the sidewalk will annoy other persons passing by? Hindi ba? Sabi ng American Supreme Court, that ordinance should be declared void for being vague. It imposed no standard at all because one may never know in advance what annoys some people but does not annoy others. So that becomes repugnant to the Constitution in 2 respects. It violates due process for failure to accord persons fair notice of the conduct to avoid. Second, it leaves law enforcers unbridled discretion in carrying out its provisions. You get the point? So that the ordinance was declared void by the American Supreme Court for being vague. Coates versus City of Cincinnati. However, the court cautioned, according to the Supreme Court, the act or the law must be utterly vague on its face, meaning to say, it cannot be clarified by either a saving clause or by construction. Because if it can be clarified by a saving clause or by construction, then the court should not declare that law or that act unconstitutional for being vague. Baka naman, in other words, you have to distinguish between a perfectly vague act or law from one which was imperfectly crafted. So, the act must be utterly vague on its face for it to be declared void. Meaning to say, it cannot be clarified by either a saving clause or by statutory construction. Because if it can be saved by saving clause, or rather if it can be clarified by saving clause or by statutory construction, then the court should not declare that act as void for being vague. You get the point? In fact, in cases like Professor Randolph David versus President GMA, Estrada versus Sandigan Bayan, the Supreme Court cautioned, sabi ng Supreme Court, this is rather a very strong medicine. And therefore, this so-called void for vagueness doctrine, this is rather a very strong medicine and should be used sparingly only. Okay? Be guided by that. Now, the other one is doctrine of overbreadth. Overbreadth. Ano yung root word niyan? Overbroad. Take it from there. Sabi ng Supreme Court, a statute may be said to be overbroad where it operates to inhibit the exercise of individual freedoms affirmatively guaranteed by the Constitution, such as the freedom of speech or religion. A statute may be said to be overbroad where it operates to inhibit the exercise of individual freedoms affirmatively guaranteed by the Constitution, such as the freedom of speech or religion. A generally worded statute, when construed to punish conduct which cannot be constitutionally punished, is unconstitutionally vague to the extent that it fails to give adequate warning of the boundary between the constitutionally permissible and the constitutionally impermissible applications of the statute. It fails to give adequate warning of the boundary between the constitutionally permissible and the constitutionally impermissible applications of the statute. That is the doctrine of overbreadth. But as you can see, under this doctrine of overbreadth, actually the act or the law itself is not really that vague. In fact, it may be clear enough. Kaya lang, in its application, it operates to inhibit the exercise of individual freedoms affirmatively guaranteed by the Constitution. In other words, it is so sweeping that it fails to give adequate warning of the boundary between the constitutionally permissible and the constitutionally impermissible applications of the statute. Okay? A good example of, or one case where the court, in declaring an act overbroad, vague for being overbroad, was in that case of Adjong versus Comelec. I don't know if you encountered that case before. Adjong versus Comelec, you know what happened there? In connection with the May 1992 elections, now by the way, in that election, mayroon pa yung tinatawag na political ad ban law. The political ad ban law was still in effect then, in the May 1992 elections. You know that political ad ban law? Yung it is prohibited to advertise your candidacy in the media, newspapers, radio, TV. Bawal. That was the political ad ban law. So if you happen to be a candidate for a public office, bawal kang mag-advertise sa radio, sa TV, sa newspapers. Bawal, precisely. Kaya nga tawag dun political ad ban law. Of course, ngayon wala na yan with the enactment by Congress of the Fair Election Act. But at that time, the political ad ban law was still in effect. Now, Adjong, in the first place, do you know Adjong? Oy. Have you heard about him before? Sister. That is the point. That is precisely the point. He was a candidate for senator. Did you know that one? He was not a nuisance candidate. He ran under the political party of Danding Kuangko, Nationalist People's Coalition. He was a neophyte in politics, baguhan. And he was running for a national office, senator. Naturally, he will have to campaign nationwide. Bawal pa yung mag-advertise because of the political ad ban law. So anong ginawa ni Adjong? To have his candidacy advertised, natural, nagpagawa siya ng mga posters, stickers, decals, and other election campaign paraphernalia. That is the only way by which, since you are a newcomer in politics and you're running for national office, senator, I said he was not a nuisance candidate. Kaya lang baguhan eh. Hindi naman siya artista eh. O komedyante eh. Hindi, wala namang exposure sa, maybe to some extent, sa lugar niya or some academic circles, he may be known, but that is a very limited clientele or audience. So yan ang ginawa niya, to have his candidacy advertised. Nagpagawa ng mga posters, stickers, other election campaign paraphernalia. Ang problema, the Comelec at that time issued a resolution prohibiting during the campaign period. Take note, the resolution says, during the campaign period prohibiting the posting of stickers, decals, posters, and other election campaign paraphernalia in public mobile places, mga sasakyan, public mobile places, except only in COMELEC designated common poster areas. So, apektado siyempre si Adjong. Bawal maglagay ng mga posters, stickers, decals in public mobile places like yung mga sasakyan. Except only in COMELEC designated common poster area. So, paano niyang i-advertise yung kandidatura niya for senator? Because of that, Adjong challenged the constitutionality of that COMELEC resolution. And the Supreme Court sustained the challenge. Indeed, sabi ng Supreme Court, that resolution should be declared void for being overbroad. The court applied there the doctrine of overbreadth. Why? Now try to analyze. Sabi ng Supreme Court, in the first place, the resolution was deceptively crafted. It was deceptively crafted in the first place. It becomes unreasonable. Why deceptively crafted? Because if you try to analyze, anong sinasabi? During the campaign period, it is prohibited to post stickers, decals, posters, and election campaign paraphernalia in public mobile places, except only in COMELEC designated common poster areas. Sabi ng Supreme Court, deceptive yan, madaya yan. Why? Because first impression, bawal ka lang maglagay ng posters ni Adjong, stickers niya, sa public mobile places. Mga sasakyan, hindi ba? But upon closer scrutiny, you will find out that even in the privacy of your own bedroom, you are prohibited by that resolution from posting stickers of Adjong. Why? Because your bedroom is not a COMELEC designated common poster area. Do you get the point? Very broad eh. Kaya nga sabi ng Supreme Court, very deceptive, pati it was deceptively crafted, it becomes unreasonable. On that score alone, sabi ng Supreme Court, that should be declared void, it becomes unreasonable. Besides, look, if you happen to, let us say, be a fan of Adjong, and then you receive, or you got a copy of the poster or sticker of Adjong, you placed it in your car or in your gate. Ano yan? You are exercising what? Your freedom of expression. You're telling the whole world that you love Adjong very much. Hindi ba that is an expression of your preference for Adjong? Part of your constitutionally guaranteed right, freedom of expression. Now, is there any substantive evil that will justify the curtailment of your freedom of expression? Pag biyang poster ba ni Adjong, nilagay mo ba dyan sa sasakyan mo o sa gate mo, magkakaroon ba ng revolusyon? Magkakaroon ba ng epidemic? Wala naman eh. No substantive evil to justify the curtailment of your freedom of expression. Yun ang sinasabi na our statute may be said to be overbroad where it operates to inhibit the exercise of individual freedoms affirmatively guaranteed by the Constitution, such as the freedom of speech or religion. Did you get the point there? So the the Supreme Court actually declared that the COMELEC resolution void for being overbroad, applying the doctrine of overbreadth. You get the point? So these are developments in due process. The void for vagueness doctrine and the doctrine of overbreadth. Sabi ko nga, lately medyo napapadala sa pag-invoke nito, ha? For example, in Estrada versus Sandiganbayan, still remember that case? The case involving plunder filed against former President Estrada. He questioned that plunder law. Sabi niya sa Supreme Court that plunder law should be declared void for being vague as well as for being overbroad. In-invoke niya yung void for vagueness doctrine as well as the doctrine of overbreadth. So he wanted the plunder law to be declared void by the Constitution on those considerations. Void for being vague as well as for being overbroad. Kasi ang sabi niya, yung definition ng plunder, ginamit yung words series of acts, combinations. Sabi niya, malabo yan, vague yan. Besides, overbroad yan. Now, did the Supreme Court agree with him? The Supreme Court did not. Ironically, according to the Supreme Court, it was you who signed this into law. And now you are now the one petitioning the court to declare that unconstitutional. Patay kang bata ka. Kaya kayo one of these days when you become a president, huwag kayong pipirma ng kung ano-ano dyan, ha? Baka kayong unang tamaan niyang pinipirmahan ninyo. At any rate, of course, the Supreme Court did not agree on the plunder law because remember, the act must be utterly vague on its face for it to be declared void. It must be utterly vague on its face, meaning to say, it cannot be clarified by either a saving clause or by construction. Because if it can be saved, but it can be clarified by a saving clause or by construction, the court should not declare it void for being vague. Take note of that. And remember that these two doctrines are rather strong medicines and therefore should be used sparingly only. Baka naman lahat ng batas na nakita nyo, gusto nyo i-declare void for being vague. These are rather strong medicines and therefore should be used sparingly only. Ganon din yung Professor Randolph David versus President GMA. The petitioners there wanted the court to declare Proclamation 1017 issued by the little girl declaring a state of national emergency on February 2006 void for being vague and for being overbroad. Of course, medyo the court did not agree. The act, remember that the act must be utterly vague, meaning to say it is not it cannot be clarified by a saving clause or by construction. Besides, sabi ng Supreme Court, itong doctrines na ito should be applied only in freedom of expression cases. Although merong dissenting opinion doon, sabi nga ng dissenting opinion, if you apply this in freedom of expression cases, why should you not apply this in criminal statutes? Especially since in criminal statutes such a basic right as the right to liberty is involved. At any rate, sabi ng majority in that case, its application should be limited only to freedom of expression cases. Okay, so take it from that. Developments in due process. So as you can see, ang tinatamaan talaga ng void for vagueness doctrine tsaka ng doctrine of overbreadth, a substantive due process. Can you imagine holding you liable for violating a law which you never understood in the first place? So it strikes deep into the very essence of due process, di ba? So take note of those, the void for vagueness doctrine and the doctrine of overbreadth. With respect to the doctrine of overbreadth, a statute may be said to be overbroad where it operates to inhibit the exercise of individual freedoms affirmatively guaranteed by the Constitution, such as the freedom of speech or religion. A generally worded statute, when construed to punish conduct which cannot be constitutionally punished, is unconstitutionally vague, to the extent that it fails to give adequate warning of the boundary between the constitutionally permissible and the constitutionally impermissible applications of the statute. Okay? So I hope that is clear. These are developments in due process. Equal protection. As I told you already, the Equal Protection Clause is a guarantee against any kind of discrimination. Neither shall anyone be denied the equal protection of the laws. A guarantee against any kind of discrimination. So how is it formulated? In its simplest formulation, anong formulation yan? Persons or things similarly situated in terms of rights conferred and obligations imposed should be treated similarly. Conversely, if they are not similarly situated, then they should not be treated similarly. That is the simplest formulation of this Equal Protection Clause. Now take note, however, that the Equal Protection Clause does not guarantee absolute equality. What it merely guarantees is equality among equals. I repeat, it does not guarantee absolute equality. What it merely guarantees is equality among equals. And because of that, as you know very well, not all classifications under the Equal Protection Clause are invalid. In fact, there may be a valid classification for as long as, ano yun? What are the requisites of a valid classification? First, the classification must be based on substantial distinctions. Second, it must be germane to the purposes of the law. Third, it must not be limited to existing conditions only. Finally, it should apply equally to all members of the class. If the classification meets the four, the classification becomes valid. There is no violation of the Equal Protection Clause. So I repeat, not all classifications are prohibited under the Equal Protection Clause. There may be a valid classification for as long as, first, the classification must be based on substantial distinction. Second, it must be germane to the purposes of the law. Third, it must not be limited to existing conditions only. And finally, it shall apply equally to all members of the class. If the classification meets the four, then the classification becomes valid. There is no violation of the Equal Protection Clause. That's why, Quinto versus Comelec. Is there a valid classification based on substantial distinction between those holding appointive office in the government and those holding elective office that will justify differential treatment? Remember, those holding appointive office under Section 66 of the Omnibus Election Code, ano yan? The moment they file the certificate of candidacy, they are ipso facto resigned. But those holding elective office, they are not resigned. So, is there a valid classification based on substantial distinction between those holding elective office and those holding appointive office that will justify differential treatment? Ano sabi ng Supreme Court in that motion for reconsideration? There is. Ano yun? First, those holding elective office, they have a mandate from the people. They are elected by the people. Whereas those holding appointive office, they have no mandate from the people. Their mandate came from the appointing authority. Second, yung security tenure ng those holding elective office very limited. Yung term of office nila is local officials 3 years, congressmen 3 years, senators, president, vice president 6 years. Samantalang those holding appointive office, they have longer tenure. Government employees, they reach the age of retirement upon reaching the age of 65. Di ba? Justices of the Supreme Court, justices and judges upon reaching the age of 70. PNP and armed forces upon reaching the age of 56. So yung tenure nila longer. Samantalang itong those holding elective office, shorter yan eh. Those holding appointive office, they become dinosaurs there in the government service, di ba? Sa haba ng serbisyo nila, naging dinosaurs niya, di ba? Uy! O yung mag-react to mga ito. Talaga, di ba? Naiging dinosaur na yan dyan sa hindi na makaalis sa upuan nila. Ang hirap mong kaya nag-follow up ka dyan ng mga papeles, di ba? Ang hirap tumayo dyan, di ba? Unless, of course, there is something in your papers. Under the papers, I should say. Mabilis yan. Oy, kung walang corrupt, walang... Ayan. Ingatan nyo yan, ha? So there is a valid classification based on substantial distinction between those holding elective office and those holding appointive office that will justify differential treatment in terms of filing of certificate of candidacy. Okay? Besides, the classification is germane to the purposes of the law. Quinto verse Comelec, motion for reconsideration. So, because of that, the constitutionality of Section 66 of the Omnibus Election Code was upheld by the Supreme Court in that motion for reconsideration. What else? Mayroon bang valid classification based on substantial distinction between print media and broadcast media that will justify differential treatment? Ano yung print media? Diaryo, magazines, comics, di ba? Tabloids. Samantalang yung broadcast media, radio, TV, wawawi, awin-awin, ano ba? Anyway. Is there a valid classification based on substantial distinction that will justify differential treatment? So that with respect to those in the broadcast media, they may be compelled to give to the Comelec free of charge radio time, TV time, where the Comelec, so that Comelec can allocate this radio time, TV time among the candidates to ensure equal opportunity in the media among candidates. Di ba? That was at the time, that was PPI versus Comelec, Telebap versus Comelec. But on the part of print media, yung mga dyaryo, they may not be compelled to give to the Comelec free of charge newspaper spaces for the same purpose during the campaign period, as held in that case of PPI versus Comelec. So mayroon bang, kasi nagreklamo yung radio, TV owners and operators. In that case of Telebap versus Comelec, sabi nila ganun, why is it that according to the Supreme Court, we can be compelled to give to the Comelec during campaign period, radio time, TV time, free of charge, for said purpose. But in the case of those in the print media, in PPI versus Comelec, sabi ng Supreme Court, to require them to give to the Comelec free of charge newspaper spaces that would constitute an unlawful exercise of the power of eminent domain. Pareho lang naman kaming media of communication. The only difference between us and them is that kami nasa broadcast media, sila nasa print media. But we are both, pareho lang naman kaming media of communication information. Why are we now being subjected to different treatment? Are we not being discriminated against here? So ano sabi ng Supreme Court? Remember that the Equal Protection Clause does not guarantee absolute equality. What it merely guarantees is equality among equals. And because of that, not all classifications are invalid under the Equal Protection Clause. There may be requisites of a valid classification. One of them is that the classification must be based on substantial distinction. Is there a valid classification based on substantial distinction between those in the print media and those in the broadcast media that will justify differential treatment as in this case? Sabi ng Supreme Court, there is. So what are those? First, print media, what do they make use of in their publications? Yung print media, yung mga dyaryo, what do they make use of in their publications? Newspaper spaces. Those are their properties. You have to know the main source of income of those in the print media, dyaryo, magazine. Ano yung main source of income nila? Advertisements through those newspaper spaces. Subukin nyo mag-advertise sa dyaryo, maski na sa obituary section. Mahal yan. Di ba? That is the main source of income of newspapers. Now to require them to give to the COMELEC during the campaign period newspaper spaces free of charge, that will constitute a taking of private property, because that is their private property. Now, what's wrong with that? But since the COMELEC requires them to give free of charge, there is now a violation of Section 9 of the Bill of Rights. Because under Section 9, private property may not be taken for public use without just compensation. So in that case, requiring them to give free of charge to the COMELEC newspaper spaces during the campaign period, that will constitute an unlawful taking of their private property without payment of just compensation. That will violate Section 9 of the Bill of Rights. On the other hand, broadcast media, radio, TV, what do they make use of in their broadcast? Airwaves. Do they own the airwaves? No, res comunes yan. Airwaves are scarce resources, and the use of the airwaves is regulated by the state. The use of the airwaves is regulated by the state. That's why you have the government agency charged with that. What agency? National Telecommunications Commission. Since airwaves are scarce resources, the use of the airwaves is regulated by the state. So that for one to be able to operate a radio or TV station, one is given a franchise by the government. A franchise. Now, what is a franchise? A franchise is a privilege. It is a privilege. And that being the case, that is covered by Section 11 of Article 12 of the Constitution. Ano ba nakalagay dyan sa Section 11 of Article 12? Second sentence. Oy, come on, yung mga kamag-anak ni Magellan. Neither shall any such franchise or right be granted except under the condition that it shall be subject to amendment, alteration, or repeal by the Congress when the common good so requires. Sabi ng Supreme Court, the common good requires that during the campaign period, broadcast media, radio, TV, should give to the COMELEC free of charge radio time, TV time to ensure equal opportunity in the media, and also so that the people can vote intelligently. That is what the common good so requires. It is inconceivable, it is absurd, according to the Supreme Court, that these radio TV operators, they are enjoying a privilege, a franchise. The government expends considerable amount of money just to see to it that they can continue to enjoy their privilege. Now the time has come that the government would like from them something in return. The government cannot compel them. That is absurd. Remember that the government spends considerable amount of money to regulate this activity, radio, TV broadcasting, so that the franchise owners can enjoy, continue to benefit their franchise. Now the time has come when the government would like to from them something in return. That is absurd. So there is no unlawful thing of private property involved here. Because after all, what do they make use of in their broadcast? Airwaves. They do not own the airwaves. No unlawful thing of property, private property. Unlike in PPI vs. COMELEC, if you compel newspaper owners and publishers to give to the COMELEC free of charge newspaper spaces, that will constitute unlawful taking of private property, because newspaper spaces are properties owned by these newspaper owners and publishers. So there is a valid classification based on substantial distinction between the two media of communication and information. that will justify differential treatment. Besides, in terms of reach, which is more pervasive, print media or broadcast media? In terms of reach, which is more pervasive, print media or broadcast media? Broadcast media. Radio, TV, umaabot yan maski abroad eh. Maski sa the most remote areas, basta may transistor radio lang yan. Samantala itong dyaryo, limited circulation yan. Hanggang saan lang yan? Usually hanggang provincial capitals and urban centers lang yan. Pagdating ng baryo yan, hindi na dyaryo yan, history na yan. Or pambalot ng tinapa na lang yan. Hindi ba? So in terms of reach, print broadcast media is more pervasive. More pervasive. That's why, in terms of freedom of speech, freedom of expression, yung freedom of expression of those in the broadcast industry can be subject to greater regulation compared with freedom of expression of those in the print media. Because of that, print media is more pervasive. Kaya lang, now you have that more recent case, Chavez versus Secretary Raul Gonzales. Yung ipinagbawal ni Secretary Raul Gonzales, Raul Gonzales, yung airing of the Hello Garci tapes, diba? Chavez versus Gonzales. Saka pati NTC, tinreten yung mga radio, TV stations that will continue to air the Hello Garci tapes with closure, revocation of their franchise. Anong sabi ng Supreme Court dyan, unconstitutional yan, that will constitute a prior restraint on freedom of expression that cannot be allowed. It has a chilling effect on the members of media themselves. Hindi pwede yan. Prior restraint on freedom of expression. In the first place, sabi ng Supreme Court, questionable ngayang Hello Garci tapes na yan. In the first place, hindi nga established which is the authentic tape. The one showed by Secretary Bonyi or the one claimed to be the true one according to NBI Director Ong, or the one shown by, marami ng kopya nun, hindi nga malaman kung alin na authentic tapes. Secondly, hindi nga established kaninong boses yun naroon sa Hello Garci tapes. Kanino bang boses yun? Uy! Ano? Nobody has admitted that it was his or her tape, her voice there. Ay, wala. Wala siyang inamin. I'm sorry. I talked with the COMELEC official. How many COMELEC officials are there in the whole country? Wala. So, kaninong boses talaga yon? Even Commissioner Garci has denied that that was his voice there. Kaya nga, mahirap yun eh. Tapos, by airing the tape, pagbabawalan mo yung media, sabi ng Supreme Court, dubious nga, hindi nga malaman kung alin talagang authentic tape, saka sino yung kaninong boses yung naroon. Although, pag pinakinggan mo yung the voice that congratulated Manny Pacquiao, mukhang pareho eh, di ba? But remember, nobody has admitted that it was his or her tape, her voice there in the tape. Kaya nga mahirap din i-prosecute yung violation of Republic Act 4200, Anti-Wiretapping Act. Kasi for you to prosecute, establish mo muna kanilang boses yun. Wala namang nag-admit na boses niya yun. How do you prosecute violation of Republic Act 4200? Whose communication was violated? Kasi nakalagay, unlawful for any person to tape without the consent of all the parties to that private communication. Now, who are the parties in the Hello Garci tapes? Wala naman nag-admit eh. How will you prosecute? How can you prosecute Wala namang nag-admit that it was his or her voice there that was taped without his or her consent. Mahirap yan, mahirap mag-prosecute. Yun ang perfect crime. Di ba? Wala ka na, paano yung prosecute yun? Perfect crime talaga yun. Because for you to be able to prosecute, kaya na-establish muna kaninong boses yun. Kasi nakalagay, it shall be unlawful on the part of a person to tape, overhear, intercept, without the consent of all the parties to that private communication spoken word. It says there, without the consent of all the parties to any private communication spoken word. Now tell me, who are the parties in that Hello Garcia tapes? Wala na umaamin na boses niya yon. Oh. So, remember, penal laws are strictly construed against the state and liberally interpreted in favor of the accused. So, here may prosecute yun. For you to prosecute, establish mo muna kaninong voices yun. Whose private communication spoken word was intercepted, overheard, or taped, recorded without his or her consent. Anyway, we digress. But look at that, there was a very keen observation by the Supreme Court speaking through the Chief Justice, Justice Puno, at that time. Sabi niya, ang traditional view natin in terms of reach, mas pervasive yung broadcast media compared with print media. Di ba? That was the traditional notion. But nowadays, with the developments in communication like internet, computer technology, sa internet, there is now a fusion of visual and audio. So, nakikita mo kung ano yung nakaprint doon, narinig mo pati, di ba? There is now a fusion between the visual and audio communication, di ba? So there appears to be, in other words, the traditional distinction between the two media of communication information has been getting blurred nowadays with the advances in science and technology. Computer, internet, hindi ba? Fusion na ngayon yan eh. Audio-visual yung internet eh. Hoy, sino pa ba hindi nakakita ng internet dyan? Kawawa naman. Pakiwanan na kayo. Hindi ba fusion yan? Now, can you tell me now na mas pervasive yung yung broadcast media sa print media, samantalang yung internet, both print and broadcast yan eh. Audio, video yan eh. And unfortunately, sabi ni Chief Justice Puno, our laws cannot cope with these developments. Until now, there is no agency that can regulate the internet. Mayroon na bang government agency that regulates the use of the internet? Wala. Kaya dyan, naglipa na yung mga paborito nilang pornographic di ba? Di ba? Oy, you can have access to that. Even children can have access to that. Oh. Kasi wala talaga regulatory agency. The movements in science and technology and communication napakabilis that our laws cannot cope with these changes, with these developments. You get the point? Anyway, that's we're just pointing out the distinction. There is a valid classification based on substantial distinction between print media and broadcast media that will justify differential treatment. Although in recent years, the distinction between print media and broadcast media in terms of reach has become blurred already. With the advances, tremendous advances in science, technology, computer, internet, tremendous advances. Okay? So there you are. So just remember, equal protection clause. Not all classifications are invalid under the equal protection clause. Also remember that case, yung Abacada Guru Party List versus Secretary Purisima, a challenge to the custodiality of Republic Act 9335. What is Republic Act 9335? The Attrition Act of 2005. Remember, under this Attrition Act, this affects the personnel of the Bureau of Customs and Bureau of Internal Revenue. Yung Attrition Act. Pag na-exceed nila yung collections nila, yung estimated collections nila, target collections nila, they are entitled to bonus. Pag nag-fall below naman sila ng targeted ko nila, that may be a ground to remove them from the Bureau, either Bureau of Customs or Bureau of Internal Revenue. Now, the constitutionality of Republic Act 9335 was questioned in this case of Abacada Guru Party List versus Secretary Purisima. Among others, sabi ng petitioners, if you read the petitioners here, sinama pangalan ko dyan, talo kami dito. Kinwestiyon namin yun kasi, bakit sila lang? What about other government employees, teachers, policemen, minor employees? Bakit yung mga taga-customs na, taga-BIR lang? Mayroong incentives. Ang argument namin, violative of the equal protection, one of the arguments, violative of the Equal Protection Clause. There was no valid classification based on substantial distinction between government employees. How come the employees of Bureau of Customs and the Bureau of BIR, bibigyan sila ng incentive pag na-exceed nila yung target collections nila? Paano yung teachers? Paano ngayon ang mga police? Armed forces? In effect, are you not making these employees or personnel of the Bureau of Customs, Bureau of Internal Revenue mercenaries? Bounty hunters? Tinatalo kami. Sabi ng Supreme Court, equality guaranteed under the Equal Protection Clause is equality under the same conditions and among persons similarly situated. It is equality among equals, not similarity of treatment of persons who are classified based on substantial differences in relation to the object to be accomplished. When things or persons are different in fact or circumstance, they may be treated in law differently. Ano na naman yun? Petitioners claim that limiting the scope of the system of rewards and incentives only to officials and employees of the BIR and the Bureau of Customs violates the constitutional guarantee of equal protection. There is no valid basis for classification or distinction as to why such a system should not apply to officials and employees of all other government agencies. Ano sabi ng Supreme Court? The Equal Protection Clause recognizes a valid classification. That is a classification that nakakairita. Tatanong, is this the auditorium? Of course, you're disturbing the review. Bahala siya kung pare siya. Review tawag siya ng tawag dyan They should not, they know the review schedule. They should not disturb the review schedule. Nakakasira sa They're trying to focus. Asan na ngayon? Nawala na. The Equal Protection Clause recognizes a valid classification. That is a classification that has a reasonable foundation or rational basis and not arbitrary. With respect to Republic Act 9335, its expressed public policy is the optimization of the revenue generation capability and collection of the BIR and the Bureau of Customs. Since the subject of the law is revenue generation capability and collection of the BIR and the BIC, and the Bureau of Customs, I should say, the incentives and/or sanctions provided in the law should logically pertain to the said agencies. They should logically pertain to the said agencies. Moreover, the law concerns only the BIR and the Bureau of Customs because they have the common distinct primary function of generating revenues for the national government through the collection of taxes, customs, duties, fees, and charges. Both the BIR and the Bureau of Customs are bureaus under the Department of Finance. They principally perform the special function of being the instrumentalities through which the state exercises one of its inherent functions, taxation. Indubitably, such substantial distinction is germane and intimately related to the purpose of the law. Hence, the classification and treatment according to the BIR and the Bureau of Customs and the Republic Act 9335 should fully satisfy the demands of equal protection. So there you are. So there is here a valid classification based on substantial distinction between the personnel of the BIR and the Bureau of Customs compared with other government personnel that will justify differential treatment. Both the BIR and the Bureau of Customs are bureaus under the Department of Finance. They principally perform the special function of being the instrumentalities through which the state exercises one of its inherent functions, taxation. Indubitably, such substantial distinction is germane and intimately related to the purpose of the law. Hence, the classification and treatment according to the BIR and the Bureau of Customs under Republic Act 9335 fully satisfy the demands of equal protection. Okay? Be guided by that. Abacada Guru Party List versus Secretary Purisima. August 14, 2008. Okay? Take note of that, Remember that the Equal Protection Clause recognizes a valid classification, a classification that has a reasonable foundation or rational basis and not arbitrary. With respect to Republic Act 9335, its expressed public policy is the optimization of the revenue generation capability and collection of the BIR and the Bureau of Customs. Since the subject of the law is revenue generation capability and collection of the BIR and the Bureau of Customs, the incentives and or sanctions provided in the law should logically pertain to the said agencies. Moreover, the law concerns only the BIR and the Bureau of Customs because they have the common distinct primary function of generating revenues for the national government through the collection of taxes, customs, duties, fees, and charges. So there you are, Okay. Now, those are the more important matters to consider insofar as the right to the equal protection of the laws is concerned. Just remember, as I told you, the Equal Protection Clause is a guarantee against any kind of discrimination. Pero yung due process naman, if what is involved is an arbitrary act of government, arbitrary, whimsical, capricious, unreasonable, oppressive, you want to question that, that is the time when you invoke the due process clause. Pero pag pinag-usapan naman, discriminatory act, any kind of discrimination, you want to question that, that is the time for you to invoke the Equal Protection Clause. Okay? Section 2. The right against unreasonable searches and seizures. Ay, nako, paborito. One of the 4 sections of the Bill of Rights governed by the exclusionary rule in evidence. Okay? So that any evidence obtained in violation of these shall not be admissible for any purpose in any proceeding. It is excluded by the Constitution, so it becomes, what kind of evidence is that? Incompetent evidence. That evidence may be very relevant, it may be material, but it is incompetent since it is excluded by the Constitution and therefore not admissible. In any proceeding and for any purpose, take note of that. Not admissible for any purpose in any proceeding. Meaning to say, hindi lang criminal proceeding, even in civil cases, even in impeachment cases, in administrative cases. Now, take note also, first of all, that the right extends not only to one's person, it extends as well to one's house, one's papers, one's effects. So the protection extends not only to one's person, but even to one's house, one's papers, one's effects. However, remember that not all searches and arrests and seizures are prohibited. What are prohibited only are the unreasonable searches, arrests, seizures. So, question, when do you consider a search or arrest or seizure to be unreasonable and therefore prohibited? General rule, if it is not covered by a search warrant or warrant of arrest. General rule. Although, as you know very well, there may be instances of valid warrantless arrest, there may be instances of valid warrantless searches. But as a general rule, a search or arrest or seizure is prohibited if it is not covered by a search warrant or warrant of arrest. And in this regard, you have to consider what are the requisites for the issuance of a valid search warrant or warrant of arrest. Hoy, be sure to be familiar with those, ha? Apat yan. Ano yun? There must be probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant, and the witness may produce particularly describing the place to be searched or the persons or things to be seized or arrested. Apat yan. Now, in connection with the fourth, do not forget Stonehill versus Jokno, that old case. What did the court say there in Stonehill versus Jokno? That is in connection with the fourth requirement, particularly describing the place to be searched and the persons or things to be seized or arrested. Anong sabi ng Stonehill versus Jokno? Oy, nako! The search warrant or warrant of arrest must always be issued in connection with a specific offense. A general warrant will not do because actually a general warrant partakes of a nature of a fishing expedition for evidence by the state. That cannot be allowed. Example of a general warrant, like in that case of Stonehill versus Jokno. That was an example of a general warrant. Sabi ng Supreme Court, hindi pwede yan. Look, tingnan nyo. Ano nakalagay doon sa search warrant? To search the offices of Stonehill at the port area. Nakalagay doon, for violation of the Tariff and Customs Code. Sabi ng Supreme Court, tika mo na, there are so many offenses under the Tariff and Customs Code. You have to specify which. That is a general warrant. A general warrant will not do. A general warrant partakes of a nature of a fishing expedition for evidence by the state. Because indeed, you can just imagine, halimbawa ikaw, mayroong warrant for arrest, tapos nakalagay doon sa warrant of arrest mo, for violation of the revised penal code. Uy, how many felonies are there in the revised penal code? Kung mga 300 lang yan, meron yan. That is a general warrant. You have to specify which of the felonies there. Is it in connection with murder, physical injuries, estafa, robbery, theft? Wag naman yung ganong for violation of the revised penal code. Ang daming felonies under the revised penal code. Yun. Tandaan nyo yan, in connection with the fourth requirement, particularly describing the place to be searched and the persons who thinks to be seized or arrested. Do not forget Stonehill versus Jokno. The search warrant or warrant of arrest must always be issued in connection with a specific offense. A general warrant will not do, because a general warrant actually partakes of a nature of a fishing expedition for evidence by the state. Okay? Now, remember, baka mamaya kayo, pauwi ka na mamaya, malapit ka na sa bahay mo, sinalubong ka ng barangay tanod, inaaresto ka ng barangay tanod, tinanong mo, mayroon ka bang warrant of arrest? Meron. Ito, pinirmahan ni Kapitan, punong barangay. Nagparesto ka rin. Maswerte ka. Only a judge may issue a search warrant or warrant of arrest. That is a judicial function. Take note of that. Not even the prosecutor may issue a search warrant or warrant of arrest. Only a judge. Do not forget that one. Actually, we reverted to the 1935 Constitution. 1935 Constitution, only a judge may issue a warrant of a search warrant or warrant of arrest. Kaya lang, 1970 Constitution, during the martial law years of President Marcos, he had the 1970 Constitution amended. Tapos, with respect to that provision, dinagdagan. That was part of the amendments. It says there, and such other officers as may be authorized by law. Kaya under the 1970 Constitution, because of that amendment, not only a judge may issue a search warrant or warrant of arrest, because the provision says, as amended, and such other officers as may be authorized. Uy. Okay, nagulat ako eh. Such other officers as may be authorized by law. And because of that, on that basis, that's why even when martial law had already been lifted, 1983, but still the effects of martial law can be felt. Kasi nagpaparesto pa noon si Marcos, pati si Defense Minister Enrile. Yung tinatawag na the infamous ASO. What is ASO? ASSO. Arrest, Search, and Seizure Orders. Sila nag-i-issue noon. Pag gusto nila magpa-aresto, mag-i-issue ng ASO, aarestuhin ka. That's why even when martial law was supposed to have already been lifted in 1983, still the effects of martial law could be felt because of that. Now, after the EDSA revolution of 87, February 86, I should say, so you now have the framers of this new constitution. Inalis nila yung phrase, and such other officers as may be authorized by law. Inalis na yun. Kaya ngayon, bumalik tayo sa 1935 Constitution that only a judge may issue a search warrant or warrant of arrest. You better remember that one. And because of that, in Salazar versus Atsacoso, still remember that case? The provision of the labor code, because if you read the labor code really, there was a provision there which says authorizing the Secretary of Labor to issue search warrants and warrants of arrest in illegal recruitment cases. That provision of the labor code was declared unconstitutional by the Supreme Court in that case of Salazar versus Atsacoso for being inconsistent with Section 2, Article 3, that only a judge may issue search warrant or warrant of arrest. Yung labor code na yun was enacted during the martial law years pa. At that time, valid pa yung provision na yun. Because at that time, not only a judge may issue a search warrant or warrant of arrest, because the 1970 Constitution amended says, and such other officers as may be authorized by law. But with this new constitution, that provision is now inconsistent with this. That's why that provision of the labor code empowering the Secretary of Labor to issue search warrants and warrants of arrest in illegal recruitment cases that was invalidated by the Supreme Court in that case of Salazar versus Atchacoso. Do not forget that one, huh? So, only a judge may issue a search warrant or warrant of arrest. Nobody else. Huwag kayo magpaparesto dyan. Baka kung sino-sino lang dyan maaresto sa inyo dyan. Paresto naman kayo. Masaya kayo. Okay? Now, probable cause. First among the requisites, there must be probable cause. To be determined by whom? By the judge personally. Probable cause to be determined by the judge personally after examination under oath or affirmation of the complainant and the witnesses may produce, particularly describing the place to be searched and the persons or things to be seized or arrested. Okay? Now, determination of probable cause. Now, you better take note of this. Actually, if you consider your criminal procedure, actually, in your criminal procedure, there are two determinations of probable cause. There are two determinations of probable cause. The first one is made by whom? When? For what purpose? Huh? For what purpose? For the purpose of filing the information court. The second one is made by whom? For what purpose? Can you visualize? Let us not study this in the abstract. How is a criminal case commenced? It is commenced by filing the complaint. Where? Who files the complaint? Private offended party, or in cases where there are no private offended parties, like, can you think of a case where there is no private offended party? Rebellion. Mayroon mang private offended party dyan. It is the state. Kalaban mo dyan. Rebellion. Drugs. More often, walang private offended party. Illegal possession of firearms. So, who files the complaint? The private offended party, like the victim of physical injuries, the victim of rape, theft, robbery. Di ba? Or in offenses where there are no private offended parties, the law enforcement officers. Where is it filed? Prosecutor's office. So, what will the prosecutor do now? Will he dance for joy? What will he do? He will conduct preliminary investigation. What rule? Kaya pala, yung commencement, what rule? 110, 110. Kasi 111, independent civil actions eh. Tapos 112, preliminary investigation. During preliminary investigation, ano talaga ginagawa ng prosecutor? During PI, what actually he does is determine probable cause. That is the first instance in your criminal proceeding where there is a determination of probable cause. It is the prosecutor who determines probable cause for what purpose? For the purpose of filing the information in court. Now, the moment the information is filed in court, what happens? The proceeding is automatically converted into a judicial proceeding, subject now to the control of the judge, so that nobody can dictate on the judge on how to dispose of that case, not even by the Secretary of Justice. Not even the Secretary of Justice. Anong ruling yan? Crespo versus Mugol. That was the essence of Crespo versus Mugol. Once the information is filed in court, the proceeding is automatically converted into a judicial proceeding. Before that, the proceeding remains to be executive. There at the prosecutor's office, a prosecutor is an officer under the Department of Justice, a department under the executive branch. But the moment the information is filed in court, the proceeding is automatically converted into a judicial proceeding, subject now to the control of the judge, so that nobody can dictate to the judge on how to dispose of that case, not even the Secretary of Justice. That was the essence of the ruling in Crespo versus Mogul. Kaya nga ginawa ni Secretary Agra, pinapadismiss yung case against the Ampatuans. Na-file na sa RTC yung kaso eh. Sabi nga, pinitot kagad ni former Chief Justice Arteme Panganiban. Tika muna, Crespo versus Mogul ito ha. The case had already been filed there in the RTC. So, may the Secretary of Justice still order for the dismissal of that case? He cannot dictate on the judge. Terrible. That is the essence of the ruling in Crespo versus Mogul. You have to understand that one. Naku-convert yan ang proceeding into a judicial proceeding. Okay. So, as you can see there the distinction between a criminal complaint and a criminal information. So, a criminal complaint is one that is filed in the prosecutor's office. Who files it? It's either the private offended party, or in offenses where there are no private offended parties, the law enforcement office is concerned. In what form is it filed? In a complaint affidavit. Sinumpaang salaysay. Hindi ba? Once the complaint is filed in the prosecutor's office, the prosecutor will now conduct PI. During the PI, actually, he determines probable cause. For what purpose? For the purpose of filing the information in court. Now, the moment the case is filed, the information is filed in court. So the one that is filed in court is not a complaint. It is the information. Who files the information? The prosecutor. There lies the big difference between criminal complaint and criminal information. A complaint is filed in the prosecutor's office, and information is filed in court. Who files the complaint? Private offended party or law enforcement officer. Who files the information? The prosecutor, after conducting PI. So judicial na yung proceeding, nasa korte na. So, may trial now proceed. May trial now proceed. Why not yet? Ano na pag-arraignment? The court has not yet acquired jurisdiction over the person of the accused. You know that very well. How can the trial proceed when the court has not yet acquired jurisdiction? The first must first acquire jurisdiction over the person of the accused. Now, how will the court acquire jurisdiction? Two ways. First, if he voluntarily surrenders. Second, if not, if he is arrested. But before he can be arrested, anong kailangan? Sino mag-i-issue niyan? The police? Ayan. So, but before a judge issues a warrant of arrest, what will he do? So, there is the second determination of probable cause. Kaya nga, beginning with that case, Sullivan versus Macasyar, marami na yan. Abdullah versus Giani, Sullivan versus Macasyar, Aliado versus Jokno, marami yan. Hanggang Abdullah versus Giani. Ano sabi ng Supreme Court? The determination of probable cause for the purpose of filing the information in court, that is an executive function. That is a function that belongs to the prosecutor. The prosecutor is an officer under the Department of Justice, a department under the executive branch. On the other hand, the determination of probable cause for the purpose of issuing a warrant of arrest or a search warrant, that is a judicial function. Why? Because under Section 2 of the Bill of Rights, only a judge may issue a warrant of arrest or a search warrant. Judicial function yan. Yan. And because of that, ano yung sabi ng Supreme Court? The judge is not bound by the determination of probable cause by the prosecutor. In fact, he should not rely solely on the finding of probable cause by the prosecutor. Why? Because he is mandated by Section 2 of the Bill of Rights to determine probable cause. Personally, he cannot abdicate the performance of that function in favor of the prosecutor if he wants to remain faithful to the Constitution. That's because of that. Actually, many warrants were ordered by the Supreme Court to be quashed on that consideration. Because the court found that the judge did not determine probable cause personally. He relied solely on the finding of probable cause by the prosecutor. Hindi pwede yan. In those cases, the court not only ordered for the quashal of the warrant of arrest that was issued, but the judge was even sanctioned. The judge in such a case opens himself for possible sanction by the Supreme Court. He did not determine probable cause personally. He abdicated the performance of that function in favor of the prosecutor. Hindi pwede yan. Hindi pwede yan. That is very significant. Sullivan vs. Macasiar, Aliado vs. Jokno, Abdullah vs. Giani, marami na yan eh. The judge is not bound by the finding of probable cause by the prosecutor. In fact, he should not rely solely on the finding of probable cause by the prosecutor. Why? He is required by the Constitution, Section 2 of the Bill of Rights, to determine probable cause personally. If he wants to remain faithful to the Constitution, he should determine probable cause personally. Okay? You get the point, huh? With respect to the determination of probable cause. Pagkatapos, after examination under oath or affirmation of the complainant and the witnesses may produce. Now, ano yung development? Government of the USA versus Judge Purganan. Isingit nyo na ngayon yan. In extradition cases, before a judge issues a warrant of arrest of an extraditee, is prior notice or hearing required on two bases. One of them is constitutional. Sabi ng Supreme Court, you read Section 2 of the Bill of Rights. Is prior notice or hearing required before a judge issues a warrant of arrest? It's not. It says there must be probable cause to be determined personally by the judge after examination under oath or affirmation of whom? Of the accused? Of the extraditee? No. Of the complainants and the witness may produce, particularly describing the place to be searched or the persons or things to be arrested. There is no requirement that before a judge issues a warrant of arrest, he should conduct prior notice or hearing. On the contrary, the Constitution says, after examination under oath or affirmation of whom? Of the accused? No. Of the complainant and the witnesses he may produce. That is a development. Diyan yung sisingit nyo na ngayon yung second Mark Jimenez case, Government of the USA versus Judge Purganan. Before a judge issues a warrant of arrest in an extradition proceeding, is prior notice or hearing required? On two bases, no. First, statutory, on the basis of Section 6 of PD 1069, which we discussed yesterday extensively. Second, constitutional, Section 2, Article 3. There is no requirement under Section 2 of Article 3 that before a judge issues a warrant of arrest, he must conduct prior notice or hearing. No such requirement there. In fact, in Webb versus De Leon, sabi ng Supreme Court, we categorically held that the judge is not required to conduct notice or hearing before issuing a warrant of arrest. Okay? Be guided by that. So, familiarize yourselves with the requisites for the valid issuance of a search warrant or warrant of arrest. Apat yan. Huwag kayong pa-aresto sa barangay tanod, O di kaya, tapos tignan nyo kaagad sino nakapirma sa warrant of arrest. Baka yung parish priest nyo nakapirma dyan, nagpa-aresto rin kayo dyan, Only a judge may issue a search warrant or warrant of arrest. Now, by the way, what is the lifespan of a search warrant. Oy! Search warrant. What about warrant of arrest? Oy! Wala yan. Yung search warrant, 10 days lang yan. Pero warrant of arrest, wala yan. Kaya lang may requirement after 10 days upon issuance, the warrant officer must make a return to the judge, indicating whether the arrest had been served and the person arrested. Kung wala, mag-issue ng alias warrant. Can you serve a warrant of arrest in Thailand? Nag-isip pa, paano nga mag-serve ng warrant of Thailand outside of our jurisdiction? Kayo naman talaga. Nag-isip pa. Thailand na yan. You can only enforce territoriality principle. We can only enforce our criminal laws in our territorial jurisdiction. In such a case, ano remedy mo? Kung mayroong extradition treaty, extradition. Huwag ka magsasearch ng warrant of arrest doon sa outside of our jurisdiction. Ano ka? You are inviting disaster. Baka gusto mo magkagera. You're violating the national sovereignty territory. Ay, nako, kinokorrelate natin sa international law pati eh. Ay, presence of mind. I know that you know that. Kaya lang nabigla kayo eh. Nagpapagulat-gulat din kasi kayo eh. Saka talagang sisigaw talaga ako rito. Yes, there are some who are engaged who indulge in peaceful picketing. Di ba? Panggising din yan. Ayan. So there you are. Now, let us now consider general rule. For a search to be valid or an arrest to be valid, there must be a search warrant or warrant of arrest. But then by way of exceptions, there may be instances of valid warrantless searches or valid warrantless arrest. Now, umpisahan natin sa valid warrantless arrest. How many? Uy! Warrantless arrest. Ilan? Hindi sila sigurado. Nagugulat sila. 3. What section? What rule? Yan. Anong section? Section 5, anong rule? Bakit sinabi 114? 113. Arrest yun. 114 is bail. You are not familiar with your criminal procedure, ha? Basta pinag-usapan instances of valid warrantless arrest. 3 lang yan. Huwag ninyong dagdagan yan, ha? Section 5, Rule 113 of the Rules of Court. Yung una dyan, in flagrante delicto arrest. Second one is arrest in hot pursuit. Third is arrest of an escapee. Walang problema yung number 3. Madaling intindihin yun. Ha? Takas yan eh. Whether he is a convicted felon serving his sentence and then he escaped, or he is a mere detention prisoner awaiting trial and then he escaped, or he's being transferred from one place of confinement to another and then he escaped. In which case, he may be arrested even without warrant. For obvious reason, takas yan. Pugante arrest. Arrest of an escapee. Now, by the way, this warrantless arrest under Section 5, Rule 103, not only a law enforcement officer may effect this. Even an ordinary citizen. Di ba? Anong tawag doon? Yes. Not only a law enforcement officer. Kaya lang, I will advise you, huwag kayong magtapang-tapangan dyan, ha? You leave that to the police and the law enforcement officers. They're trained for that. Otherwise, what will happen to you, walang silbi yung bayaning patay. Babalutin ka ng bandila dyan. Tapos maglalamay dyan yung mga kapitbahay mo at ang barkada mo, alalakas uminom ng kape niyan. Magpupusoy doon sa lamay mo, magdodomino yan. Ang ingay pati ng mga yan. You leave that to the law enforcement officers. They are trained for that. They are trained for that. Huwag kang magtatapang-tapangan. Lalo na yung mga snatchers. Ay, nako. Ingat kayo dyan, ha? Okay, so there you are. Now, let us tackle. Ang usual problem is with respect to determination of which applies. 1 or 2. Kasi yung 3 madali, takas yan eh. Pero yung 1 or 2, that is where the trouble lies. Analyze, ha? Ano sinasabi essentially ng the first in flagrante delicto arrest? By the way, ha? Consistent ng Supreme Court dito, ha? Instances of in flagrante delicto arrest. Arrest as a result of a bypass operation. Sabi ng Supreme Court, in flagrante delicto arrest yan. Arrest as a result of entrapment operations. Consistent yan. Arrest as a result of entrapment operation, arrest as a result of a bypass operation, consistent ng Supreme Court. Those were instances of in flagrante delicto arrest. Ano ang meaning ng in flagrante delicto? Caught in the act. Now, analyze the provision. Substantially, sinasabi dyan, Section 5, Rule 103, yung number 1. An offense has just been, in his presence. Yung pinaka-importanting phrase dyan to remember is in his presence. An offense has just been committed, is being committed, or is about to be committed. In his presence. In other words here, the arresting officer or person has personal knowledge of the commission of the offense. Why? It has just been committed. It is being committed. It is about to be committed in his presence. So, he has personal knowledge of the commission of the offense. Kaya nga tawag diyan, in flagrante delicto arrest. Caught in the act. In his presence, an offense has just been committed, the immediate past, is being committed, the continuing present, is about to be committed, the immediate future, in his presence. So yan ang key word dyan, key phrase to remember, yung in his presence. So, the arresting officer person has personal knowledge of the commission of the offense. He can effect a warrantless arrest. For example, you are a police officer, nagpapatrolya ka one night. Tapos diyan nakita mo sa tabindahan, may ginagahasa. Oh, tapos sabi, oy, stop ka muna, kuha muna ako ng warrant of arrest. In flagrante delicto arrest, since you have personal knowledge of the commission of the offense, you can arrest him. Right there and then. Yung pangalawa, yung more difficult to determine. You know why? Kasi substantially it says, yung number 2, yung arrest in hot pursuit. Substantially sinasabi dyan, an offense has in fact just been committed, and then the arresting person, officer or person has, hindi, ano kayo yung change introduced by the new rules of criminal procedure, December 1, 2000, has probable cause, siningit yan eh. An offense has in fact just been committed, and then the arresting officer or person has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed it. Siningit na yung phrase na has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed it. Now, let me ask you a question. In the second case, yung bang arresting officer person, mayroon ba siyang personal knowledge of the offense? Mayroon ba siya noon? Wala, kasi kung mayroon siya noon, that will fall under number 1. In flagrante delicto arrest. Here, what he has is personal knowledge of what? Facts and circumstances, not of the commission of the offense. He has personal knowledge of facts and circumstances. There must be several of these, facts and circumstances, which, when taken together, will elevate that now into a probable cause to believe on his part that the person to be arrested committed the crime. You get the point? Pero actually, the arresting officer person here does not have personal knowledge of the crime. Because if he has, that will fall under number 1. What he has is personal knowledge of facts and circumstances, which when taken together, these facts and circumstances of which he has personal knowledge of, when taken together, will elevate that now into a probable cause to believe on his part that the person to be arrested has committed it. To illustrate, let us assume that you are a police officer. You were patrolling dyan sa Plaza Miranda. Hoy, sino pa bang hindi nakapunta ng Plaza Miranda dyan? Huwag kayo magpipretend, ha? Saan yun? Binondo, sabi niya. Anong Binondo? Harap ng Quiapo Church. That is a very busy place. Hindi ba? No. Let us say, 10 o'clock in the morning, nagpapatrolya ka dyan sa Plaza Miranda. Between yung Mercury Drug sa yung Quiapo Church. Tapos narinig mo a voice of an old lady shouting, "Tulong, tulong, snatcher." Paglingon mo, nakita mo yung lalaki, tumatakbo mabilis. Unusual. Bakit siya tatakbo na mabilis? Tapos, may dala-dala siyang handbag. Unusual. Kalalaki niyang tao, may dala-dala siyang handbag. Ano yan? Ladlad. Oo. Tapos nakita mo yung victim, tinuturo siya. Tulong, tulong. An old lady, tulong, tulong is snatcher. Oh. Can you arrest him? Under the circumstances, yes. Did you see the actual snatching? You did not. But you have personal knowledge of facts and circumstances. Ano yun? First, you heard the voice of an old lady shouting, "Tulong, tulong is snatcher." Paglingon mo, unusual, ba't siya tatakbo nung pagkabilis-bilis? Tapos kalalaki niyang tao, dala-dala niya handbag, ano yan? Tapos, tinuturo ng victim yung... All of those facts and circumstances of which you have personal knowledge of, when taken together, will elevate that now into a probable cause to believe on your part that it was he who committed the snatching. Can you arrest him? Of course. Arrest in hot pursuit. But did you see the actual snatching? You did not. Because had you seen the actual snatching, that will fall under number 1. In your presence, an offense has just been committed, is being committed or is about to be committed. In this case, you did not see the actual snatching. Okay? Pero you have personal knowledge of facts and circumstances which, when taken together, will elevate that now into a probable cause to believe on your part that the person to be arrested is the one who committed it. Kaya nga tawag dyan, arrest in hot pursuit. There lies the difference between the two. Pero ang hirap i-determine at times yan, ha? Medyo borderline case ka dyan, drawing the line ka dyan. That's why that demands familiarity with the requisites. Okay. So you have there, pag pinag-usapan warrantless arrest, tatlo lang yan, automatic in your mind. Section 5, Rule 113 of the Rules of Court, Rules of Criminal Procedure. Yung una, in flagrante delicto arrest. Yung pangalawa, arrest in hot pursuit. Yung pangatlo, arrest of an escapee. Examples of in flagrante delicto arrest, consistent na yung Supreme Court dyan, ha? Arrest as a result of an entrapment operation, arrest as a result of a buy-bust operation. Kunyan, in flagrante delicto arrest. Consistent ang Supreme Court. Okay? Now, ang pwedeng manggulo dyan, Uy, what happened? Oh. Hindi na tayo iba dyan, may na. Titiis na lang nila yan. Di ba nakakahiya pag ganun, di ba? Okay. Ako, nahihirapan nila ko rito. Baka kala nyo, pinipigil ko lang dito. Bakit kayo lang ba? Okay, there you are. Ang pwede manggulo dyan, ito. Umil versus Ramos. A very controversial decision of the Supreme Court. Unfortunately, until now, this is still in our statute books. This has not been abandoned, this ruling. Yan ang pwedeng manggulo dyan. Now, let us analyze the facts of that case so that you can properly appreciate the issue there. Now, Umil versus Ramos. $10 in the morning, along Avenida Rizal. Alam naman niyo, Avenida Rizal, mahaba yan. Magmula Carriedo, Manila Side hanggang Monumento, Caloocan. Di ba? Ito nangyari sa Caloocan side ng Avenida Rizal. 10 o'clock in the morning, a police patrol car was ambushed. 2 of the police occupants died. Okay? In that ambush. Tapos, according to some bystanders, one of the assailants even stood on top of the hood of that patrol car. He shouted, "Mabuhay ang Alex Bungkayaw Brigade." Tapos nawala na. You know the Alex Bungkayaw Brigade? The liquidation squad of the New People's Army. Tapos nawala na. Several minutes later, dumating na yung reinforcements, police reinforcements. Wala na, patay na yung dalawa eh. Kaya lang they interviewed some of the bystanders in the area. Now, according to one of the bystanders, yun hong isang pulis, bago ho namatay yun, nakaganti ho yun, nakaputok ho yun, and one of the assailants was wounded. Now, take note, that was the only information there. There was not even an identification of who the wounded assailant was. Basta as general as that, isa ho sa mga pulis, bago namatay, nakaganti ho yun, nakaputok yun, and one of the assailants was wounded. Now, so on that basis, ito yung mga pulis, iniikot nila lahat ng hospitals and medical clinics nearby. They're looking for a man with fresh gunshot wound. So negative, wala. But they left a word. Sabi nilang ganon sa lahat ng hospital at medical clinics sa nearby. Pag may dinala rito lalaki, gunshot wound, tawagan nyo kami rito sa numero ito sa presinto. Okay? The next day, one of the doctors in a nearby hospital called up the police station. Sabing ganon, mayroon dito lalaki, dinala, gunshot wound. So the police officers rushed to that hospital. Inaresto nila yung tao, nasa hospital bed. Okay? Wala silang warrant. No. They brought him to Camp Crami, they interrogated him, and he confessed that indeed he was among the assailants and that he was a member of the New People's Army. Confession, extrajudicial. Now, during the trial, the defense counsel was questioning the regularity of the arrest. Because when he was arrested in the hospital, the police officers were not armed with a warrant of arrest. So the defense counsel was questioning the regularity of the arrest. Okay. Now, wag na natin pag-usapan whether the arrest was valid or not. Kasi sabi ng majority ng Supreme Court, valid daw. So, wag natin pag-usapan kung valid or not. According to the majority of the Supreme Court, valid. So, if it must be valid, it should fall under any of the three. Alin sa tatlo? Can you apply number 3? Hindi pwede, hindi takas ito eh. So, eliminate natin number 3. So, it's either 1 or 2 lang yan. Di ba? Can you apply number 1? Ano sinasabi ng number 1? In his presence. Were they present when the ambush took place? They were not. So, obviously, we eliminate number 1. That leaves us with number 2. Ano sinasabi ng number 2? An offense has in fact just been committed. The arresting officer person has probable cause to believe based on personal knowledge of facts and circumstances that a person to be arrested is the one who committed it. Now, in the first place, in number 2, the time element is very material. It says there, an offense has in fact just been committed. Dito, kailan nag-take place yung arrest? A day later. The time element in number 2 is very material. The provision says, an offense has in fact just been committed. The police officers have all the time to secure a warrant of arrest. They did not. Besides, do they have personal knowledge of facts and circumstances? Wala. Ano bang impormasyon nila? Sabi ng bystander, yung isang pulis, nakaganti, bago namatay, nakaputok, may tama. There was not even an identification of a person who was hit. Hindi ba? Tapos the other information, yung tawag ng doktor, mayroon dito dinala lalaki, gunshot wound. Neither was there identification. As or those facts and circumstances, do they have personal knowledge of? So obviously you cannot also apply number 2. Yet, sabi ng majority of the Supreme Court, valid yan. Under number 1. Ayan, di nagtaka kayo. He is a rebel. And rebellion is a continuing offense. He is deemed to be committing an offense in the presence of the arresting officers. He is a rebel. And rebellion is a continuing offense. Kaya galit na galit yung mga justices nag-dissent. Sabi ng mga nag-dissent ng justices, among them, if I remember it, was Isagani Cruz. Alam naman yun si Isagani Cruz. Sabi, is this not a case of putting the cart before the horse? At that precise moment when you arrested him at the hospital, were you already sure that he is a rebel? Hindi kayo sigurado. Inaresto nyo muna siya, dinala nyo sa krami, in-interrogate nyo, that was the only time when you are able to determine that he is a rebel. But at that precise moment, when you arrested him, you are not sure. At any rate, that was the dissenting opinion. Ang sabi ng majority, justified yan. He is a rebel. And rebellion is a continuing offense. So he is deemed to be committing an offense in the presence of the arresting officers. Ginamit yung number 1. As I told you, a very controversial ruling. Kaya lang, Umil versus Ramos has not been abandoned. It's still there in our statute books until today. Kaya yan ang sinasabi ko, yan ang pwedeng manggulo dyan. With respect to the so-called continuing offenses. What are the continuing offenses? One of them is rebellion. Ano pa? Kidnapping is a continuing offense. Transporting marijuana or drugs. Yan ang pwedeng manggulo dyan. Okay? So you have to view that in its proper context. Umil versus Ramos. Very interesting. Yan ang pwedeng manggulo dyan. Okay, na puntahan naman natin yung instances of valid warrantless arrest. Marami yan, warrantless searches. I'm sorry. Instances of valid warrantless searches. Yan, marami yan. Of course, the most common among the instances of valid warrantless searches, ano yung the most common? Oy. Yes. What section, what rule? Section 13, Rule 126 of the Rules of Court, search incident to lawful arrest. I said, this is the most common. Ito yung nakikita natin in movies, in TV shows, in not only here but even abroad, or even in actual situations, hindi ba? Hindi ba nyo napapansin, pag ang pulis o yung NBI nag-aresto, ano yan? Taas kamay, harap sa pader, tapos kakapkapan ka. Or more often, pag lalaki yan, dapa, tapos pag-uhubarin niya ng hanggang tuhod para hindi makatakbo. Yan ang search. Ay, nako. Dito na naman tayo sa Discovery Channel talaga. Yan, Discovery Channel na yan. Yan, SOP. Yan ang search incident to lawful arrest. Pag nag-aresto yung police or NBI or law enforcement officers, taas kamay para hindi ka maano tapos magsa-search yan. You know why? SOP yan, Standard Operating Procedure. That is a measure of self-defense on the part of the arresting officers. Because many of the police casualties, not only in the Philippines but even in the United States and other jurisdictions, victims of that. Nag-aresto, hindi nag-search, yung pala armado, binaril yung police, sinaksak. Marami ng police casualties because of that. So that is SOP, part of the training of law enforcement officers. Pag nag-aresto ka, mag-search ka. So as you can see, measure of self-defense on the part of the law enforcement officers. That is part of their training. Tsaka yung purpose pati niyan, aside from measure of self-defense, self-protection yan, to acquire objects or effect of the crime, like the stolen wallet or stolen cell phone or the knife used in hold-up. Yan ang purpose niyan. Kaya search incident to lawful arrest. Sa atin, mga pulis at mabait pa eh. Sa Amerika, pag nag-aresto yan, pupusasan ka talaga, sasalya ka talaga niyan. Di ba? Huwag mo sabihin babae ka. Sasalya ka niya sa ano, tapos pupusasan ka, tapos magsasearch yan. You have seen this in American movies, di ba? Mas malupit sila roon. Sa atin, mabait pa yung pulis natin. At least taas kamay ka lang, tapos kapakapan ng ano. Eh, paano sinanla na yung posas? Wala nang pamposas yung mga pulis natin. Sa liit ng sweldo. Hindi ba? Hoy! Naisanla pati posas sa Liwiliers or sa ano? Sa mga... There you are. Okay, take note. Yan ang search incident to lawful arrest. That is, I said, that is the most common that we see. Ang purpose niyan, measure of self-protection on the part of the arresting officers. Not only that, in order to secure an object or effect of the crime, like the stolen wallet, the stolen cell phone, or the knife used in hold-up. Yan ang purpose niyan. Okay, now, there are three important matters to remember for this warrantless search to be valid. Three important matters to remember. First, sabi ng Supreme Court, in this kind of warrantless search, the arrest always precedes the search. The process cannot be reversed. People versus Chua Hosan, citing Malacat West Court of Appeals. In this kind of a warrantless search, the arrest always precedes the search. Nauna yung arrest bago magsa-search. The process cannot be reversed, sabi ng Supreme Court. Kaya pag nakita nyo from the facts, nauna yung search bago yung arrest, ay ibang klaseng search yan. Definitely that is not a search incident to lawful arrest. Second important thing to remember, the precedent arrest must be lawful. Because if the precedent arrest was unlawful, the subsequent search, although it may have yielded positive result, can never validate the unlawful arrest that preceded it. That is very important. Kasi as worded even in Section 13 of Rule 126, it says, search incident to a lawful arrest. The word arrest was qualified by the word lawful. Kaya nga, the precedent arrest must be lawful. Because if the precedent arrest was unlawful, the subsequent search, although it may have yielded positive result, can never validate the unlawful arrest that preceded it. And finally, since this is a search incident to lawful arrest, the search must be limited only, or must be confined only, within the immediate vicinity of the place of the arrest. It cannot be extended beyond that. I repeat, since this is merely a search incident to lawful arrest, the search must be confined only within the immediate vicinity of the place of the arrest. It cannot be extended beyond that. Okay? You got it by those, Yung pangatlo was best illustrated in that case of application of the third was best illustrated in the case of Nolasco versus Cruz Panyo. You know what happened there? Nolasco versus Cruz Panyo. She was standing at the jeepney stop along Kamuning, waiting for a jeepney ride. Of course, you know Kamuning, Again, those who are not familiar with the geography of Metro Manila, Kamuning, nakatayo siya sa jeepney stop along Kamuning, waiting for a jeepney ride. Quezon City yan. Tapos, nakita siya ng mga pulis. Nakita siya ng mga pulis. Inaresto ngayon siya sa jeepney stop doon. Walang problem with the arrest kasi the police officers were armed with a warrant of arrest. Inaresto siya doon sa jeepney stop. Now, after arresting her, the police officers proceeded to her residence. Malayo Ito yung jeepney stop, malayo residence niya. Pumunta yung mga pulis doon sa residence niya, nag-conduct na search. Wala silang search warrant. They were able to obtain one unlicensed firearm and assorted rebel propaganda materials. Ayan. So during the trial, the defense counsel was now objecting to the introduction in evidence of that unlicensed firearm and the assorted rebel propaganda materials obtained under those circumstances. Sabi ng defense counsel, not admissible in evidence. They were obtained without a search warrant. Inadmissible yan. Sabi naman ng prosecution, admissible. This was a case of valid search incident to lawful arrest. Now, did the Supreme Court agree? Now, sabi ng Supreme Court, where was she arrested? She was arrested at the jeepney stop along Kamuning, waiting for a jeepney ride. Were the police officers armed with a warrant of arrest? They were armed. Okay, no problem with that. Now, these evidences, where were they obtained? They were obtained in her residence. Her residence, how far was it from the place of the arrest? Uy, malayo. Sabi ng Supreme Court, this will not qualify as a search incident to a lawful arrest. When we talk of a search incident to lawful arrest, the search must be confined only within the immediate vicinity of the place of the arrest. It cannot be extended beyond that. Here, the police officers, if they really wanted to search a residence, they have all the time to secure a search warrant. All they should have done is cordon the whole area, and then somebody apply for a search warrant. After all, it's not difficult to secure a search warrant. They have all the time to secure a search warrant. They did not. After all, her house cannot run away. This will not qualify as a search incident to lawful arrest. So you see, and because of that, since the evidences obtained were not admissible, they being the fruit of the poisonous tree, wala nang ebidensya. She had to be acquitted on reasonable doubt. Can you imagine that one? Wala nang ebidensya because the evidences were rendered inadmissible since they were obtained under those circumstances. So she had to be acquitted on reasonable doubt. Can you imagine that one? Ganun lang kasi, kaano. So you have to be keen on this kasi it could spell the difference between liberty and incarceration. So there you are, ha? Kasi talaga, ang sabi ko sa inyo, ang main purpose niyan is an act of self-defense on the part of the arresting officer. So it cannot be extended beyond that. Dapat doon lang sa within the immediate vicinity of the place of the arrest, that is subject to control by the police officers. After all, this is merely an exception. Remember, general rule is before there can be a valid search or a valid arrest, there must be a search warrant or warrant of arrest. These are exceptions. So, as exceptions, they should not be liberally interpreted. So there you are. So what are the three requisites for this kind of search to qualify as a search incident to a lawful arrest? First, the search or the arrest must always precede the search. The process cannot be reversed. Second, the precedent arrest must always be lawful, because if the precedent arrest was unlawful, the subsequent search can never validate the unlawful arrest that preceded it. Third, since this is merely a search incident to lawful arrest, the arrest must be, or the search must be limited only or confined only within the immediate vicinity of the place of the arrest. It cannot be extended beyond that. So remember, Nolasco versus Cruz Panyo. Yan ang pinaka-ordinary thing that we see. Okay? Let's have a break now para madami yung tumatayo eh. Ang hirap pigilin yan. Magka-kidney problem kayo dyan. And I do not wish to be responsible for that.